Welcome to Air Passenger Rights Live. My name is Dr. Gabor Lukacs. I'm the president of Air Passenger Rights. I would like to begin by thanking our volunteer moderators, Christine, who has been a moderator with us for more than 5 years now since the pandemic, and Paula, who just joined us recently. And Paula is coming to us with a lot of good experience. She actually fought Air Canada in federal court without any prior legal experience and with English being her second language. She had a 4-day trial against 5 trained lawyers, and she won her case. I just would like to remind you that I am not a lawyer. I am providing information, not legal advice. If what you are looking is legal advice, then you must speak to a trained lawyer. As I'm sure you know, we are a volunteer organization, we are a non-profit organization, and everything that we do is funded by you, the viewers, the passengers who are following us, and we don't accept any government funding or any corporate funding from industry. We are just here for you. Even this microphone that I'm currently wearing is from donations that you have provided to us, and it is very much appreciated. If you have a moment and if you are able to afford it, please consider clicking on the donate button here on our website and supporting the work that we do. You probably know that we ask when you join the group to provide your social media handle and to follow us on Twitter or Blue Sky or Mastodon. We have been asked questions about why it is necessary, what is the purpose. So I would like to answer that question as we are starting up. The purpose of social media is to amplify the message that we are putting out. It is not possible in Canada of 2025 to do any kind of advocacy work without a group of stakeholders, passengers, patients, if it is a medical field, consumers who are there, who can speak on what they have experienced and who can support and validate what advocacy is about. It is also a question of how politics are done in Canada of 2025. Social media does play an important role in how politics are done at this day and age. So the reason that we ask that you follow us on one of the social media channels like Twitter or Blue Sky or Mastodon is because that is one way how you can support the work that we are doing. That is one way how you can actually help us to get your message, your problems that you experience as passengers to decision makers, to politicians, and to the mainstream media to alert about what you are experiencing. And second public interest or public service announcement I would like to make is about a question I have been asked a number of times, which is where do you find or how do you find where to serve Air Canada or where to serve any other airline? And if you go in our Facebook group, and you are back in our Facebook group, under featured, there is a post from July 30th, 2022 that lists the addresses for service of the major Canadian airlines. And also there is a link here to a collection of addresses for service or agents for service of foreign airlines that you may be able to find. So instead of perhaps posting about it multiple times and asking where and how I can find it, you may want to just go under featured. You will also find lots of other good information in our Facebook group under featured that may be helpful to you. The main topic that I've heard many of you being very interested in and would like to hear about is your rights for standardized compensation under the European regulation, and that includes both the EU and the UK. So a chunk of what we are going to discuss today is going to focus on that. Just to begin with, we are going to go now to the European regulations, the 261 of 2004 regulations. And I am sure at some point Paula is going to also put the link into the chat here. And if she has trouble, then I will do it. So this is a set of regulations that apply to you if you are departing from the European Union on any carrier. So that's Article 3, 1A. It applies to passengers departing from an airport located in the territory of a member state to which the treaty applies. This also applies for if you were starting your travel, departing from the UK or from Iceland. This regulation has been adopted also by members of the European Economic Area. Even Switzerland adopted its own version. There's the same text of these regulations. So this is what I always refer to as the gold standard of passenger protection. We discussed before, but I would like to come back to it once more, that in the event of a flight cancellation, the European regulations require the airline to provide the passengers compensation as prescribed by Article 7. Article 7 sets out the 300, 600 euro amounts. All that is in Article 7. The key provision that in which the European regulations differ from Canada's APPR is what are the exceptions to the obligation to pay. Because in Europe, the exception is the extraordinary circumstances. So unless what happened, what caused the cancellation, falls within the extraordinary circumstances, the airline has to pay you a lump sum compensation. That would be 600 euros for if you were delayed over 4 hours as a result of the flight cancellation. It would be half of that, 300 euros, if the delay is more than 3 hours but less than 4 hours. And as always, the question is, what does extraordinary circumstances mean? That's what we are going to discuss next. That is the crux of your entitlement to compensation if you were traveling from the European Union and Europe or the European Economic Area, the UK, to Canada, what actually falls within extraordinary circumstances. I recall already getting a question about it in the group, because if you look at the preambles to the European regulation, a poster correctly mentioned that strikes that affect the operation of an air carrier is listed as something that may be an exceptional circumstance under Title 14, but that's not the end of the story. And the reason that it's not the end of the story is because the intent of this is situations where, say, air traffic controllers go on strike, or employees at the airport who are unrelated to the airline, not in a contractual relationship with the airline, go on strike, or say border services go on strike, which somehow affects the airline. These are not the airline's own employees. These are not the airline's contracting partners. These are just third parties that affect the airline's operation. And those would be viewed as extraordinary circumstances. However, just the airline's own employees going on strike is not extraordinary circumstances. So let's look at some cases on that. The first case that comes to my mind is CS versus Eurowings. And you will see the link probably in the chat. And thank you, Paula, for posting the previous link. This was a case decided in 2021 by the European Court of Justice, or Court of Justice of the European Union. They are the apex court of the European Union. They are the top court. So they are binding upon any European national court. They are the European equivalent of the Supreme Court of Canada, the same way that the Supreme Court of Canada's decisions are binding on provincial superior courts and provincial appellate courts. The European Court of Justice's decisions are binding on European national apex courts and down the way. So they are really at the top of the food chain type of court. And the question here was, again, of course, what happens in the case of a strike? I'm not going to go through the entire ruling, but they always have a nice habit of summarizing the decision at the very, very end. And the upshot of this decision is that a situation of a strike, when we are talking about a strike, in this case was the parent company of which the air carrier is a subsidiary. So when the staff of the subsidiary were necessary to operate the flights, and which even continues originally announced by a trade union, and it even was lasting beyond the period where the trade union announced a strike, is not covered by the concept of extraordinary circumstances. So even though it was a strike, even though the strike went beyond what they expected, still the ultimate ruling is that it is not extraordinary circumstances within the meaning of the European legislation, and that means that the airline is on the hook for paying you not just meals and accommodation, which is always owed in Europe, but also lump sum compensation. The second case that comes to my mind, and this ties back to the question I received, I think it was yesterday, about how things work in the United States, is a ruling from the UK Appellate Court. And I'm going to also show you a little bit just how I do research, because it's one thing to have all these links somewhere or have all these cases stored somewhere, but it's also important that you see how the sausage is being made, how actually I'm finding cases, or if I forget where the link is, how I'm finding it. So this was a case where what I can remember about it easily, that it involved the Civil Aviation Authority of the UK and Ryanair, and looking for a judgment, and it was a court of appeal. Just a first attempt at search, and lo and behold, the first item coming up is the judgment from the UK court's website. And again, you are going to find a link to this very shortly in the chat. So let's scroll down. The question here is, as usual, whether a strike action by employees of the airline constitutes extraordinary circumstances within the meaning of the European regulations. And yet again, the answer that the court comes back with is no, these are not extraordinary circumstances. When you scroll down to the end of the decision, lots of judicial ink spilled, but ultimately, the upshot is that, in my view, the judge was right to reject Ryanair's contention that the flight cancellation at issue were caused by extraordinary circumstances in his impressive judgment. The strikes from which the cancellations arose, relating as they did to employment conditions of employees of Ryanair, did not constitute extraordinary circumstances, whether or not the aims of the strikers were reasonable or achievable, and notwithstanding the involvement of trade unions. So this is, if you are in the UK or were traveling from the UK, this is the decision that you want to remember, that you want to cite. And this is your support for what you are saying. There's one more case that comes to mind, and that comes to the argument that I heard people being told on the phone. It is just, of course, secondhand information, but one passenger reported to me that they phoned Air Canada and some agent told them, no, you are not owed this type of European compensation because this was an illegal strike, because the strike was ruled unlawful by the Industrial Labor Relations Board. So let's see what the law says on that from Europe. The keyword that I remembered is Wildcat strike. So Wildcat strike EU 261 of 2004. And let's again find out. For this one, it may be a bit more tricky to find it. But third item is coming up already from the European Top Court. And here's the decision. That was actually 2018. That's the Cushman versus TUI Fly case. In this case, it was actually a wildcat strike and a lawful strike. People calling in and saying, I believe, calling in sick, which I don't blame them for doing it. And here's what the European top court had to say on it. It's a long European-style legal writing. So the spontaneous absence of significant part of the flight crew, wildcat strike, following a call echoed not by the staff representatives of the company, but spontaneously by the workers themselves, who placed themselves on sick leave, is not covered by the concept of extraordinary circumstances within the meaning of that provision. So what the European Union ultimately ruled is that even though it was an illegal strike, or wildcat strike as they say, still it is something for which the airline has to pay lump sum compensation. And the rationale is always that these type of situations are not far-fetched from the normal operation of any business. So the primarily way of thinking about it is that this is not in any way different than any other business just managing its labor force. It's not external to the airline. The airline can simply deal differently with its labor force, and it has to negotiate with them in good faith. That's the ultimate framework behind this. This brings me to the next point, which is how you can actually submit those to Air Canada. So I would like to show you two forms or two interfaces we have found, and we have received some positive reports. These, of course, keep changing all the time. So let's see, the first one was this Microsoft CRM portals link to refund assistance labor action. And let me just say that refund is a bit of a misnomer. It should be more reimbursement assistance. This is if you need reimbursement of an alternate method of transportation, additional accommodation, and out-of-pocket expenses. And here you can actually file accommodation, out-of-pocket expenses, or other form of transportation type of claims. I'm not sure, I haven't gone to the next page. Previously, there was a text area here where you could actually enter more details. I'm not sure what the next page looks as of today, but if you have any text area, then that's one place where you can assert your rights under the European regulations and say, in addition to all this, please provide me with standardized compensation in accordance with the European regulations. The second place where you can assert this is perhaps on this form, and at least I received one report where the passenger, after going to the next screen, got some kind of text area where they could assert also their rights under the European regulations. Again, all this keep changing, so if tomorrow there's something entirely different, we may have to adopt, may have to roll with the blows, we have to maybe then again keep sending it to Air Canada's chief legal officer. If Air Canada has a reasonable interface, which provides you with confirmation when you file something, and you can take maybe a screenshot of what you're filing, and if they're really willing to work with you through a reasonable online interface, then of course the goal is not to flood anybody's inbox at Air Canada. However, if Air Canada is trying to stonewall you and tell you, no, we are not going to even engage in this kind of discussions, we are not going to let you even submit it, then it is a different matter. Then, of course, writing to the chief legal officer, who is in charge of receiving legal notices, is the right and adequate action. Now, Natalie is adding here some valuable new information. Thank you, Natalie. The next page is a drop-down menu where you choose what you're asking, e.g., accommodation, food, etc. So if there is somewhere a text area, and previously I've seen a Twitter post where the passenger said, yes, that's how I submitted it. If there's a text page where you can actually add some free text, there you can assert your right to European style compensation, the EU 261 of 2004 compensation. always the last option is sending an email to Air Canada's chief legal officer. And if they don't want to pay, we can talk about what can be done about that. So let's see so just in terms of ideas. First, I would go for the refund assistance due to labor action. Then I would do this page, which we have been discussing, where Natalie said there's some more information there. Then there's also a national enforcement body for the European regulations. Each country in Europe has a national enforcement body that you can actually complain to them. And this is the latest list. And Paula kindly already posted the link to it. So depending on which state you departed from, you can actually send this body a complaint as well. This is not the only way that you want to complain about, but make sure that if Air Canada were to be unreasonable and were uncooperative, they don't get away with it and the European bodies get notified. And of course, there is always the option of serving Air Canada with small claims court papers. I would hope that in the current atmosphere, in the current public climate, perhaps Air Canada would be a bit more reasonable, would be a bit more thoughtful, and just do what is required by the law and not try to be combative with passengers. This brings me now to a different question, which is what happens if you booked your vacation or your travel through a vacation package or with Aeroplan or third parties. And just Natalie is saying that is answering that this is not link is not found. Natalie, I'm going to give you also a link that I'm using. There may have been something truncated in the process. I hope that this link is working. I found that I'm going to give you one more link, and this is here. So among the 3 links, you should probably be able to find a national enforcement body. But now again, we are going forward to dealing with what happens when you didn't book with Air Canada. They have been, previously when you look at this page, they were trying to tell you, oh, it's only if it's booked with us, only if you booked it through us. But still, they're asking here for a booking reference and a ticket number. So I'm wondering if there may be still some resistance there to dealing with tickets booked otherwise. So let's see what actually the law says on this type of situations when you buy your transportation, not directly from Air Canada, but through a third party, a reseller, a travel agent, or another airline. So first of all, we are going to look at the Air Passenger Protection Regulations. And how do we find APPR? I'm putting in Google search CANLI, because I always like to look things up on Canadian Legal Information Institute's website, and APPR. And the first item coming up is a copy of the APPR on CANLI. So let's have a look at that. I'm scrolling down now to section 2, subsection 1. And the key phrase here is the carrier operating a flight is liable to passengers with respect to the obligations set out in section 7 to 22 and 24. So let's again digest it. And I'm just looking at the link here that was pasted. I'm going to try to paste it myself. I'm wondering if somehow the way that things are being pasted are getting mangled. I'm going to paste it myself to see if things get mangled this time as well. Probably yes, I'm not sure. What I've done with this link is I also highlighted there the specific words. The link I actually put in there is already taking you right to these words and highlighting the keywords. The significance of this is that it explains that however you purchase your ticket, however you, whether you bought it, paid for it using Aeroplans, went to a travel agency, or even bought the ticket through a different airline, what matters is that Air Canada was the operating carrier. They were operating your flight, and therefore they owe you the obligations set out under the APPR. But this is not the end of the story. There's actually a decision from the Federal Court of Appeal from 2016. And this was a case, you may remember New Leaf saga. There have been issues with them trying to resell flights just before Flare. And there have been some concerns that they may be trying to shirk their obligations to passengers on the basis that they are just a reseller, they are not the airline. So the appeal was dismissed actually, but the grounds for dismissing the appeal that I put forward actually solve a great deal of the concerns that we had about passengers' rights. And I'm going to scroll down to paragraph 8 and the last sentence, which is the important part. The last sentence is, the involvement of a reseller does not obviate the requirement that licensees comply with all the obligations imposed upon them under the Act. Licensees refers here to airlines that hold a license to operate, a license for transportation of passengers to and from Canada. So this is a further court decision that reaffirms the common sense that given how Canada's regulatory regime works, even if the ticket is sold through a third party, the licensee, the airline, is still responsible for following what is set out in its tariff, in the terms and conditions, and that includes, of course, compliance with the APPR. I would like to also show you, and I'm going to come back into questions, one more place to further get reassurance that you are barking up the right tree when you demand Air Canada to provide refunds for even if a ticket was bought to a different airline, when you ask Air Canada to reimburse you for expenses that you incurred, even if the ticket was bought through a different airline or Aeroplan. And that is the Montreal Convention. So let's remember the Montreal Convention is part of the Federal Carriage by Air Act. So let's put again in a search, CANLI Carriage by Air Act. And the first item coming up is the Federal Carriage by Air Act. And we want the Montreal Convention. So the Montreal Convention is Schedule 6. One has to quite scroll down to it. This is Schedule 6 here. What I actually have done is I have prepared a link here that Paul is going to probably put in there. That takes you right to that area. And now we're going to scroll down to carriage by air performed by a person other than the contracting carrier. So this refers to situations where, say you had a Lufthansa ticket, you bought a ticket from Lufthansa, perhaps even the ticket is sold or the flight is sold as Lufthansa flight 4742, giving you a number, but actually the flight is operated by Air Canada. So Article 39 of the Montreal Convention explains what is the contracting carrier. That's the person that makes a contract with you as a passenger. And it explains also what is the operating carrier, or in this case, they call it actual carrier. And that's the actual other person who carries out the carriage. So in this case, if you bought a flight from Lufthansa on flight Lufthansa 4272, that you have been trying to come to Canada with, I'm just giving you a random number, and then that flight is canceled because it's operated by Air Canada, and then Air Canada says, no, go back to Lufthansa because it was their flight, we just operate the flight. The answer here is no, Air Canada. Under Article 40 of the Montreal Convention, both the contracting carrier and the actual carrier are subject to the convention. And the actual carrier, or operating carrier, is liable for the carriage that they were supposed to perform. So if you had another flight connecting to the Air Canada flight by Lufthansa, and that something went wrong on a flight operated by Lufthansa, that's Lufthansa's problem. But if Air Canada operates a flight that is sold under Lufthansa's number as a codeshare, then Air Canada is also liable for anything that goes wrong on that flight under the Montreal Convention. I'm going now to go back to looking at questions. I'm seeing here some concern, a question by Vera, who has trouble finding the link or things not working. I'm going to have a look at it myself. Vera, I can tell you that for me, the link that was posted works fine. I'm going to paste the link here again, just in case. But I can tell you that the link worked fine for me. So I'm not sure why it is not working for you. Try this link that I put in the chat. I hope this time it's going to work. One more topic that I promised to talk about is class actions. There's lots of talk about it, and pretty much anytime somebody is upset, they're going to say, oh, we are going to have a class action. And class action are very important tools to hold an airline accountable for misconduct, for shortchanging passengers. It's also a very important tool for holding any company accountable. But let's drill down to how class actions work. The first thing to remember about class action that it is essentially a procedure for determining rights. It is not a special right of passengers. It's not something special in the sense that it is going to have a better outcome for the individual passenger. Rather, a class action is a way for society to conserve resources. When there is a common question of law or common question of facts, or both, that a court needs to determine, which is going to affect the rights of many parties, then it is far more economical to have a single proceeding by one judge looking at the evidence and issuing a ruling that is then binding on everybody who is affected by it. So class proceedings their purpose is to save judicial resources. The idea is that there is one or two or a few representative plaintiffs who, in the name of everybody else in a particular situation, that's called a class, is asserting some rights. They have a court case, they provide evidence, they instruct lawyers, or lawyers act for them to argue the legal points. And once that ruling is issued in the class proceeding, then it is binding on everybody who is in the class. Now, Canada is an opt-out type of system in class proceedings. What this means is that once a class proceeding has been certified, and certified means a judge looked at the pleadings and said, I believe that there is something to look into here, and I believe that there is sufficient commonality of issues, and the plaintiff has a experienced counsel who can represent a class, and there is a whole list of criteria for certifying a class action. A judge is preliminarily issues a ruling to say that the court is going to deal with these issues as a class action. So just when a class action lawsuit is filed, it is nothing more than a proposed class action. But once the class action is certified, then the plaintiff and their lawyer are accepted by the court as representing the entire class, and the class needs to be carefully defined by the judge who certifies the class action. And then the focus shifts from the procedure, whether class action is suitable for dealing with the question, to the merits of the case. Once a class action is certified, typically there's a requirement to notify class members in some way. And at that point, members of the class who want to, for example, pursue their legal actions on their own, rather than as part of the class action, can choose to opt out. This is what I mentioned, that Canada is an opt-out type of jurisdiction. In Canada, passengers, in this case, can opt out from a class action, but if a class action is certified and they don't opt out, then they're automatically deemed to be opt-in or included in the class. And once a ruling is issued that's binding upon them, and whatever compensation reimbursement is ruled in the passenger's favor in the class action, that's what will be their right. And if the class action is dismissed on its merits, then they are stuck with that ruling. So this is how roughly class actions work. When I see an email I get from, or a message from a passenger saying, I want to join the class action, well, you cannot really join a class action because either you are in the class that is certified by the court or you are not. If you are, then you can possibly opt out from class actions, but there's no way to join them. Just the court joins you in when it certifies a class action. The way that whether you are in or out in a class action depends on how the class is defined in the order of the court that certifies a class action. I think this is all I can offer now on the class actions. I know that there are two proposed class actions, to be precise, against Air Canada that were filed in Quebec, both arising from the situation with the strike. And I don't know which of them is going to be certified. There can be some issues with two competing proposed class actions. Who is going to have carriage of the class action if they really overlap or are about the same issues? What I'm seeing so far is that Air Canada has been trying to make steps that it will be able to argue in court that they have already done everything that the class action is asking them to do, so they don't owe anything anymore, and the class action is futile. That's where Air Canada is gearing up toward, and that's the reason that whether or not the class actions are going eventually to be certified, what I'm sure is that those lawyers who filed those class actions did a great service to Canadian travelers because they mounted the necessary public attention and pressure, legal pressure on Air Canada to do its very best, or to have a financial interest now in doing its best to be able to avoid the class action proceeding. What Air Canada wants to do, that I'm quite sure, is to show up in court when it comes to certification and say, my lord, my lady, your honor, we have already compensated everybody. We have paid all this amount, so the class action is moot. We have already done anyway what you are being asked by the plaintiff to us to pay. Whether the court is going to bite or not, that's of course is a different question. That's for the lawyers for the plaintiff and Air Canada's lawyers to duke out in court. I also, there are some questions here from Carmela, and I'm going to take now a break from the agenda and look at the questions. So Carmela is asking, is there a deadline to submit the Air Canada claim after your travel disruption? For example, do you have to submit within 30 days of your travel disruption? No, Carmela, there's no deadline when you submit your claim to Air Canada under the Montreal Convention or the European regulations when you are delayed as a passenger. However, I would say that I would submit it as quickly as possible. Air Canada may need their sweet time to respond. They said 6 weeks, even though 30 days is what is standard in the law. So I would submit it as quickly as possible if it is practical, because ultimately, to my knowledge, and again, I'm not a lawyer, in most provinces, 2 years is the statute of limitations. So if they do something to you, then generally you have to sue within 2 years, or else you lose, you forfeit your right to sue. I'm also seeing here a question. Are additional roam-like home charges incurred because of flight disruption and 2 unplanned days out of country eligible for reimbursement as reasonable expense? I would say yes. Carmela is saying the reason I'm waiting to submit Air Canada is I want to get our phone bill. We incurred $96 for extra roam-like home charges. So roaming charges are perfectly normal in these circumstances, both under the Montreal Convention and under the European rules, which require them to also provide you telecommunication. But under the Montreal Convention, yes, I've seen cases, at least one case that comes to my mind vividly, that where even the Canadian Transportation Agency ordered some kind of roaming charges, if my memory serves me right. So the answer is yes, and waiting for the phone bill is reasonable. It shows that you are serious, that you are not trying to just make a bogus claim, but rather that you are taking very seriously your obligation to show Air Canada that you incur damages. So well done, Carmela. Abdullah is asking, do I have an obligation to inform them that I already traveled and I'm not going to fly back on a flight they booked me on 7 days later? Abdullah, it's a very interesting question. I would say that common sense and good faith would say yes, you notify the airline. In terms of choice of words, I would be very careful in not enabling the airline to be able to say that you reject the alternate transportation they offered you under the APPR. Rather, I would send them an email saying, I'm writing to you because Air Canada failed to provide me with alternate transportation that meets the APPR's requirement, and therefore I had no choice but buying a ticket on a different carrier, a receipt of which has already been filed. Please be advised that I will not need the transportation Air Canada has offered, which is not consistent with the APPR and does not meet the legal requirements that Air Canada was required to meet. So it's important that you, in your email, very clearly create a paper trail, that you're not just saying, I don't like what you offered me. Because if you just don't like it, Air Canada may say, well, we'll just refund you your unused airfare, and that's it. What you need to convey is that you are rejecting what they are saying. You're actually saying that what they offered you is really nothing. So you want to put yourself in a situation where it is clear from the paper trail that what they offered you is no different than not offering you alternate transportation at all, because what they are offering you does not meet the APPR's legal obligations. They were required to buy you a ticket on a competitor if the next available flight on Air Canada's own is in 7 days from now. That's section 18 sub 1.1 sub A, and let's go there. Let's just, why I don't like to just blab about things, but let's just go there. So we're going to go back now we are now in the APPR, the Air Passenger Protection Regulations, and answering Abdullah's question about alternate transportation. So under section 18 sub 1, Air Canada's obligation was to rebook Abdullah or the passenger on a confirmed reservation on next available flight that is operated by the original carrier or a carrier with which the original carrier has a commercial agreement, is traveling on any reasonable route, and departs within 48 hours of the departure time that is indicated on that ticket. So basically, they were required to rebook Abdullah on the next available flight on Air Canada or partner airlines, departing within 48 hours of the original departure time. Based on what Abdullah is telling us, they are offering a ticket 7 days later. 7 days later is not within 48 hours. So if Air Canada is unable to meet this, then Air Canada was required by the APPR to offer alternate transportation in the case of a large carrier, next available flight is operated by any carrier. So Air Canada, that's what Air Canada was required to do. And because Air Canada did not do so, and Abdullah purchased a ticket on his own, whatever Air Canada is offering within 7 days does not meet either 18 sub 1 or 18 sub 1.1. It is not within 48 hours. It is not the next available flight on any carrier, because Abdullah already got a ticket just much sooner, which proves that what Air Canada is offering in 7 days is not the next available flight, but just some flight Air Canada found on its own. Angela is asking now, and let's look at Angela's question. Our August 20 flight was canceled. We are rebooked onto a Wildcat flight for today, and today is the 24th of August, which was canceled and no notification sent from Wildcat. Now, flight is booked for Tuesday. We are flying UK to Canada. Is now Wildcat responsible to get us home? I assume we cannot contact Air Canada to rebook us now. Are we also entitled to 600 euros per airline, or is it a one-time thing? So in Europe, each time they rebook you, if that rebooking is cancelled, that's a new 600 euros. So now it sounds like you have a 600 euro claim against Air Canada, another 600 euro claim against WestJet. Who is responsible in this situation? I cannot pull out from a case law on this from the top of my head. I would contact probably both WestJet and Air Canada. I would be inclined to think that it's more WestJet responsible at this point because you are rebooked on them. But if it comes to that, I would say both, because you were not in the situation to have to even fly WestJet had Air Canada flight wasn't canceled. So for the 600 euros for the WestJet flight cancellation, that's WestJet's responsibility because they are the operating carrier, and the European regulations impose that kind of and the UK regulations impose that type of liability on the operating carrier. For finding you something else, that's probably WestJet. There's also a question of, is there no other flight today or tomorrow? Because if there is, they have to rebook you on that, unless this was, if WestJet's flight was canceled for reasons genuinely outside of WestJet's control, like a snowstorm middle of summer, that would be a different story. But if, say, WestJet had a mechanical issue with their flight, that would still be within the carrier's control, but required for safety reasons. So they do have to, those type of situations that are not outside but inside the carrier's control, they are Section 17. And Section 17 has a far more stringent requirements. There, the airline has to rebook the passenger on its own or partner airlines departing within 9 hours of the original departure time, failing which they have to find a booking on any carrier which is traveling on reasonable air routes. So it's not clear that rebooking you on a flight departing 48 hours from the WestJet flight meets the requirements of 17.1a sub 2. I would say it doesn't meet, because now we are talking about within the carrier's control, mind you. But it says here also that they have to rebook you to ensure that you complete your itinerary as soon as feasible. So they just cannot just give you something in 2 days and if there is something sooner, in situations which are within the carrier's control. Once you watch this video, rewatch this video, make sure that you kind of scroll back and forth. You look at how Section 17 sub 1 operates, and then scroll down and look at how 18.1 and 18.1.1 operate. They are different, and it's important to understand that 18 and 18.1 and 18.1.1 apply if it is a Section 10 situation outside the carrier's control. Section 17 apply if it is paragraphs 11 or 12, which is within the carrier's control, whether or not it's security or safety reasons or not. So they are quite different provisions here, and make sure that you roll back and forth to understand what these provisions cover and what they entitle you. Carmela is still asking, where can I find the Air Canada form for 600 euros? So Carmela, we began about this at the beginning of the show. We had these two links that I'm going to show you. We had this one here, the refund assistance due to labor action, and we had this other one. What I have seen others do, and it was reported it worked for them, is that they submitted something on this form and added a free text, if there was a free text box, to seek also European, UK 600 euro style compensation. If that doesn't work for some reason, I would write to Air Canada's Chief Legal Officer and ask them to deal with that. Natalie is asking, Air Canada failed to find us a flight home within 48 hours. However, they did ultimately fly us home 4 days later. Do we have any further rights to claim? Flew from home from Barcelona Friday instead of last Monday. So, Natalie, if you flew from Barcelona, first of all, you're owed 600 euros per passenger, and that's under the European regulations. The fact that they did not rebook you on anything within 48 hours, it raises a concern if there was anything available on other airlines. If Air Canada failed to rebook you on other airlines, even though there were flights available, then you may be able somehow to claim additional damages. The question is what damages you incurred. Natalie is saying that she's stuck with this form. It gets stuck and cannot proceed. Natalie, I'm happy to look into this later. Perhaps you want to post some screenshots with your personal information redacted, of course. We can try to look into this later. I don't know what is happening with the forms. I've seen earlier today some error messages, some server errors. I can very well imagine that Air Canada's servers are overwhelmed, and there are so many people who have been inconvenienced, who have been harmed by this situation, that I would not be surprised if that was the case. Just, I would say, I'm not the person who typically advocates for giving too much time to Air Canada, but in this case, I will give it a little bit of time. Perhaps try tomorrow again if it is just an error message that pops up. If there's something more than that, some screenshots posted in a Facebook group, again, with personal information redacted, would be helpful, and we could have a great discussion about what can be done. If there's any problem, there's always, if Air Canada is beginning to stonewall passengers with legitimate claims, then we may need to notify members of the media to alert them that there is a problem here. But so far, I have not seen sufficient evidence that Air Canada is just refusing to pay the European compensations. What I've been seeing, at least in some cases, is that they said, yes, we're going to pay it, or we are looking into this. What is clear to me that they have to pay it. That's a no-brainer. Whether they are going to pay it voluntarily or after some pressure, that's yet to be seen. But what I am sensing here is that Air Canada really doesn't want this fiasco to further escalate, to further blow up in their face. So I'm cautiously optimistic that this time they are just going to pay, because they realize that the alternative is far, far worse. Which brings me to the other issue that I listed, which I know that it may be somewhat foreign to Canadian way of doing things, but perhaps we have to have this discussion publicly. It relates to the possibility of laying quasi-criminal charges against Air Canada and its executives for breaking the APPR in a systemic and calculated manner, which is what you have all been experiencing when Air Canada failed to rebook you on competitors and refused to rebook you on competitors, which is something I've seen and heard people also talk about. So let's see where it is coming from, and I'm referring here to provisions from the Canada Transportation Act. So again, we are going to go to our Google, and we are going to figure out how to find the Canada Transportation Act. So let's see, Canada Transportation Act, and we're going to Canada Transportation Act, and now I'm going to put here hash and then section 174. That's the quick way to get to the right section. Here we are. So section 174 says, every person who contravenes a provision of this act or regulation or order made under this act, other than an order made under section 47, is guilty of an offense punishable on summary conviction and is liable, in the case of an individual, to a fine not exceeding $5,000, in the case of a corporation, to a fine not exceeding $25,000. So let's first break it down. Any such offense is punishable on a summary conviction. That's a criminal court. It will be provincial criminal court, but that's a criminal court. It's similar to, it's a regulatory offense, it's a quasi-criminal type of offense created by Parliament. Certainly, I'm saying quasi-criminal because this is not under the criminal code. I don't want you to think that this is exactly the same view or same seriousness of crime as some of the criminal code provisions, but it is still a crime. It is still, the challenge, of course, is that on a summary conviction, you have to prove the guilt beyond reasonable doubt, as opposed to a balance of probabilities. But I venture to say that perhaps it is something that should be tested, and the time is ripe for it in the current situation with Air Canada. APPR is a regulation made under the Act. The Air Passenger Protection Regulations are a regulation made under the Canada Transportation Act. So violations of APPR could be prosecuted criminally by way of summary conviction offenses. And the reason that it would be important this time to not just issue fines through the CTA administrative monetary penalties process, which also exists but is often very, very weak and no significant fines are being issued, is because of Section 175. Section 175 says that where a corporation commits an offense under this act, every person who at the time of the commission of the offense was a director or officer of the corporation is guilty of the like offense, unless the act or omission constituting the offense took place with the other person's knowledge or consent, or the person exercised all due diligence to prevent the commission of the offense. So this is where Air Canada's directors, officers could actually be facing personal liability for the immense hurt, the immense harm that many passengers suffer because of Air Canada's failure to rebook them as required by the APPR on competitor airlines. There were people who got stranded abroad, didn't have the money to come home. There were people who missed important events in their lives as a result. Not all of this may be compensable by civil proceedings. I mean, how can you compensate someone for missing the wedding of their sister or brother, missing a funeral, saying goodbyes to a loved one? These are not easily quantifiable, but many of these events, when Air Canada canceled the flight due to a strike and then failed to rebook passengers on competitor airlines that were actually available and passengers were able to book themselves on it in some cases, that should not be tolerated. That crosses the line to what is normally acceptable, decent behavior. And it would be important to set a precedent and get that message across that this type of behavior is not going to be tolerated in Canada. So if you know someone who has expertise in criminal law, perhaps a private prosecution may be a possibility. That's something possible under the criminal law. If the Crown itself will not lay charges, that's something to consider. Certainly, I would be happy to discuss those possibilities because something needs to be done. And having rules is one thing. We already have a very weak air passenger protection regulations, but we do have some APPR in place. And it does say clearly, when you look at Section 18, that they were required to rebook passengers on next available flight operated by any carrier. Yet, it was not happening. So what this shows is that merely having laws is not enough. When the laws are not being broken deliberately, knowingly, in a calculated manner, without regards to the immense suffering it is causing to the traveling public, there have to be some consequences for it, not just a slap on the wrist. And this perhaps brings me to the two final items on our agenda for today, which is what can be done and what should be done to ensure that this doesn't happen again, what we have seen, this fiasco. One part of it is fixing the air passenger protection regulations. What Canada needs is a European-style APPR, a passenger protection regime that mirrors the European Union's gold standard. If you go to our website, I've just posted today an op-ed that appeared earlier this week in the Toronto Star on flight cancelled. You would be far better off if Canada had adopted this gold standard rule for airlines. This is exactly explaining that point. I have already posted it on Twitter and on Blue Sky. If you can possibly retweet it and like it, both, it would be great. That's one way to advocate for improving the situation in Canada, is hitting social media and going there and standing up for those rights and saying, I agree, I'm retweeting and liking it. If there's a single tweet that gets hundreds, if not thousands of likes and retweets, that's going to get public attention. That signals to decision makers that that's what you want as a voter and they better pay attention to you. The other thing that I would like to show you, which is already on our website if you go back, is we have here this download report section on the right-hand side if you look at it on a big screen. And back in December 2024, the Canadian Transportation Agency put out a draft proposal for revamping the APPR. And we actually found some things that were good, but many problems in it. So we had a 29 page report submitted and is published on our website, which you're welcome to also review. On the specific issue of the strike, if you go to page, it is page number 10 at the top, page 12 of the 29 pages, we have been specifically addressing the issue of the strike and forewarn the government that there is a loophole, there is a problem, and they should fix it. So had the government listened to us back in March this year, had they actually been implementing already the revisions to the APPR, the situation currently to passengers would have been far better. It would not be so stressful. There would not be so much uncertainties. Still, of course, enforcement remains an issue. How, if Air Canada doesn't want to comply with the law, you have to do something about it yourself. But at least then your rights would have been clearer and better. So where can we actually go from here? First of all, equipped with all this information, I'm going to actually put in the link to the criticism of the government's proposal that we had in the chat. And it is giving me a hard time, so it's giving me object not found. But I'm going to try it again. So I'm going to try to put in the link. And here's a problem. I think now it's going to work. So no, still not working. You can find it on the website. I'm not sure why it is not misbehaving, but for some reason I'm having difficulty pasting in the link into the chat. But maybe third time charm. I think now it's working. Oh, Paula put it in. Thank you very much. I think for no, for her it doesn't work either. But maybe for me it's going to work now. Yes, it worked. So you're fine there. That report by us. Please call your federal member of parliament and ask to meet with them face to face. Read the report yourself before it and come prepared. Tell her or him, this is what we want done. This is how we want you, our representative, to fix Canada's passenger protection regime. Don't just have a phone meeting. Face-to-face can be very helpful. Face-to-face can be a great way of making personal connections and making sure that the member of parliament actually sees your face when you talk about how you felt when you were stranded abroad, when they just abandoned you abroad. If you want to show your emotions, that may be the right time to it, even if it is usually not what we do in Canada. If you had really a traumatic experience because you were abandoned abroad, make sure that you share those feelings with your member of parliament. They need to hear an earful from you so that then when they go back to Ottawa, to parliament, they will be able to tell, I heard from my constituents so, and they will know that these issues really, really matter to you. Another option is write a letter to the editor of your local newspaper. There was the short article I showed you from our website, the op-ed that I wrote, but you can write your own. You can use the ideas from there. You can incorporate your own. Make sure that this issue remains on the public agenda. You keep it alive. And if you don't have the time, the energy to do all of this, then at least please go to Twitter, please go to Blue Sky, and regularly retweet and like both the messages that we put out. It is important that it will not be just one person putting out a tweet, one organization putting out a tweet, but that you help us with your network, with your skills to disseminate the message, to disseminate these concerns, which are affecting hundreds of thousands of passengers. So you are not alone, but it is important that it will be visible that this is a wide systemic issue. I would like to come back to perhaps some questions that were asked. I'm going to start with Vera's question. I was not offered any transportation by Air Canada. Last communication from them was on 16th when they said they could not find tickets and offered to get a refund on their website. There were some flights, but they were not affordable for me. It was 4 of us. After many failed attempts, I reached them by phone and bought tickets with Air Transat on Saturday the 23rd. Tickets I could afford. Besides 600 euros per person, is there any amount I can request for inconvenience and negligence from Air Canada as per the Montreal Convention? I studied the documents there and his amount listed per person. However, any guidance on how to determine the amount would be appropriate. First of all, Air Canada failing to rebook you, even though there were tickets available on competitors, is a problem. This is why we have been talking about the possibility of having criminal charges or quasi-criminal charges laid against Air Canada and its execs. If there were any flights, they were required to rebook you on that, even if it was costing a lot. Second, I'm not sure where you were traveling to or from, Vera, so that's a bit missing. But if you were stranded abroad, as a result, I'm sure you had to pay for accommodation. I'm sure you had to pay for meals. I'm sure you even if you were staying with relatives, I'm sure you were contributing to their electricity expenses, something that you did as a way of showing appreciation for staying with them for an extra week. So as long as this type of payments have been happening, as long as you incurred expenses as a result of Air Canada failing its obligation to transport you, to arrange for transportation for you back home, Air Canada will be on the hook for those. If you were traveling back from Europe, also 600 euro per passenger is there. These are, so Vera is saying Rome to Ottawa. Well, it will be 600 euro per passenger for starters, plus meals, plus accommodation for starters. And let's be clear, receipts are a great way to prove that you incurred expenses, but they are not the only one. If you gave some money to your cousin that you were staying with them, maybe a letter or something signed by them saying, I acknowledge receipt of amount X for accommodation for this period would be helpful. You don't have to have formal receipt. You don't even have to have a receipt from a hotel if you can show, say, with a credit card statement that you paid. Always this type of issues, although Air Canada claims, and WestJet also loves to claim, oh, you need to have the precise receipt. In reality, what the question a judge is going to look at is, was the expense reasonable? And on a balance of probabilities, did you incur the expense or not? And is there anything that you could have done to get a receipt? Or if it was, say, normal in that particular place, but that particular situation, to not have a formal receipt, but just pay with a credit card? Judges are great with understanding real life. Judges bring to the court, when they look at your claim, not just their legal knowledge, which is vast, of course, but also they bring to the court their life experience. They know that sometimes when you travel, you forget to take a receipt, or they don't give you a receipt, or if it is a cousin that you are staying with, they don't have a formal invoice they can issue to you. So as long as it is reasonable, as long as it is backed by some evidence, if Air Canada doesn't want to pay, you take them to small claims court and make them pay. I don't think Air Canada really wants any cases coming out from this strike to go to small claims court. My hunch is that they don't want it. So as long as you are being reasonable, as long as you are not trying to stiff them, but just recover what you reasonably incurred, they should pay and they will pay. That's kind of my instinct. If things change, we have the Facebook group. We can raise a stink. We can raise concerns. We can raise alarms that Air Canada is, again, not fulfilling its obligations. Peter is asking receipts, original receipts or credit card statements? Peter, to answer your question, of course, if you happen to have an original hotel receipt, then I would scan it. I would never send the original receipt to Air Canada by mail. I would keep the original, scan it, upload it electronically. That's the best if you have it. If for some reason you don't have it, then whatever best evidence you have to substantiate, to make it likely that you incurred those expenses, that's really what you are expected to do. There's no requirement under the law to have perfect tally of all your receipts, although it would be nice if you have it, if you can have it. But Vera is saying that she was staying with relatives but did pay for groceries. If you happen to have the receipts that you paid for groceries, that's great. That's meal expenses, and you can explain the circumstances. If you at least paid for it using your credit card and you no longer have the receipts, that's good indication to substantiate that those expenses were incurred. This is not a criminal trial for you where you have to prove beyond reasonable doubt that you incurred expenses. You have to prove on a balance of probabilities that you incurred the expenses. And if you were staying somewhere for a week and you were staying with relatives, I'm sure you had to eat something. I don't think you need special expert evidence or special documentary evidence to show that you were eating something. And it stands to reason that you contributed some way to the grocery bill. If necessary, maybe a brief statement, sworn statement, or a letter from your relative. This type of things can be helpful. And Peter is talking about Roger a bill to show his roaming charges that he has to, that he incurred because to wait for hours for Air Canada. Great idea. Just make sure when you submit those invoices, your Roger bills, that you black out everything which does not actually belong, is not actually relevant to your travels, personal calls. It's not their business. So protect your privacy just as a good measure. And we have been on now for about an hour and 11 minutes, 10 minutes. So I'm done for my agenda for today. If there are still any questions, I'm happy to still answer them. But I'm going to give maybe another minute or so. But if not, then probably we can call it a day and save things for until next time. So this is the last chance for questions, for anything that may want to ask. I'm actually told now, let me just see here, there was a follow-up question. And Abdullah is asking, cannot find an email address where to send the info. So Abdullah, the email address, if you're referring to Air Canada's chief legal officer, it is something that Lizzie from the group posted many times. I don't have the email address at my fingertips, I'm afraid, but you can. It is just a typical first name, last name at Air Canada type of, email address, and just find out. You know what? Why not be I'm wondering how I can quickly, easily find it for you. Just bear with me for a moment. I'm going to try to find it for you, but I cannot promise that it is going to happen quickly. But perhaps I can. So we are looking for Air Canada's chief legal officer's email address. To be clear, I would not just randomly email people at Air Canada, but chief legal officer is normally a person who would be the right person as a last resort if nothing else is really available there normally to take legal notices. So it is Mark Barbeau, I hope I'm pronouncing Mr. Barbeau's name correctly, at aircanada.ca. It's Mark with a C. So I'm going to see if I can paste here the email address, and it's working. Yes, so here's the email address. I hope this is helpful. And now a question here from Peter. Did you refer to them to the form needed for EU compensation? There's no Air Canada form, Peter, specific to Air Canada to EU compensation. That's one of the problems. What we have been doing with that, Peter, is we have been suggesting to just go to one of these Air Canada forms, the refund assistance and the other form, and see if there is a free text field where you can assert your claim under the EU rights, EU law. If there is none, then Mr. Barbeau should be receiving an email from you. That's the best idea I have for the time being. Perhaps the biggest concern I have right now about communication from Air Canada is that they don't seem to be having a single page where you can easily select what you are claiming, whether you're claiming under the APPR or the EU regulations or UK regulations or both. Somehow that should be streamlined. It does feel still that Air Canada is perhaps not being sufficiently transparent about, or I would say sufficiently forthcoming about their obligation to pay you EU compensation. They are not really making it easy for you to claim the EU or UK compensation. But as I mentioned, I've seen at least 2 reports on X and Twitter where passengers said they have been confirmed that Air Canada was intending to pay them. So let's hope that Air Canada is going to do the right thing and not try to continue to stiff you passengers. It's yet to be seen. We are still in early stages. I wouldn't be surprised if there were some glitches, but let's hope that if we keep up the public attention, keep up the pressure to ensure that Air Canada complies with its legal obligations under both Canadian and European and international law, of course, then they will actually eventually have to do so. So I'm going to again give another maybe minute for last minute questions, because it seems that that's when I'm saying there are just last minute questions, then there are typically more questions coming in. So after a minute, probably I'm going to call it a day, but we can still look into things and give it some thought if there's something that you can do. And let me again, I know it's like a mantra, but let me say again, I would love to see more help in terms of the social media. Certainly, if you can retweet articles, messages, posts that we have on Twitter and Blue Sky. It will be great. It helps to get out the message. And if you are not following us for some reason on Blue Sky or Mastodon or Twitter or our YouTube channel as well, which you're welcome to follow, then you should do that. So please, the more channels you can help to get the group's message out, the better. The more we can make sure that this message reaches everybody, the more effective we can be. So I think that wraps up today's broadcast of Air Passenger Rights Live. Thank you very much for your attention, and we will continue the next time. Good afternoon.